Hello, and welcome to Optima Healthcare Insurance Services Directors and Officers Risk Management Recording, the effect of COVID-19 on D&O claims. I'm Millie Mastramati, Risk Management Education here at Optima. And this recording is presented by attorney Kimberly Blair of Wilson Elser Law Offices. For information about Kimberly and Wilson Elser, please open the link on the recording webpage. Also on the recording webpage, you will see a link for the evaluation of the program. We appreciate your input as we will use it to develop our D&O education for 2022. Kimberly, welcome, and I'll let you get started.
Thank you, Millie. Again, my name is Kim Blair. I am at Wilson Elser in the Chicago office. I am a directors and officers defense lawyer. And we're going to be talking today about the effect of COVID on D&O claims. And to say when I started giving these types of presentations last year in April, that I thought I would still be giving them in September 2021, I did not. That being said, I'm sure you all watch the news and follow what's going on. And if we are to listen to our elected leaders and the scientists, it looks like we may be dealing with these COVID exposures for some more time. So not only is this a timely topic, and I thank Optima for letting me speak about it, I think it's something that directors and officers are going to be dealing with for a really long time to come, and the fallout of it as well. The potential issues, with respect to directors and officers, you're running companies, you're trying to figure out how do we respond to the pandemic, not only for our patients and or customers, but our employees as well. Every company, because you're all good risk managers or you wouldn't be listening to this recording, has had contingency plans in place for something like this. Not that we could have predicted COVID-19 necessarily, but your contingency plans that you had in place are being tested today. And you as a director or officer are being tested as to how you implemented those and how you're responding to this unprecedented pandemic. And that test is going to expose, it just is, failings in our response systems or places that we could have a more robust response system. And so all of this, as we all go through the last, 15 months and maybe 15 more, knock on wood, I hope that's not true. We need to be adaptive as boards. We need to figure out where our strengths and our weaknesses are. And we need to shore up those weaknesses to make sure that we're protecting ourselves and our companies against exposure. And I'm not telling you something that you don't already know, but in the healthcare industry, employment claims are on the rise as they relate to COVID. There's like a lot of optimism about returning to normal, whatever that's going to mean. But the healthcare sector has increased its relative share of coronavirus lawsuits compared to other industries. In December of 2020, approximately 20% of lawsuits alleging labor and employment violations relating to coronavirus were from the healthcare industry. Today, it looks like those COVID-related employment claims arising from the healthcare industry are hovering around the 30% mark. So the healthcare industry, not surprisingly, is seeing more and more coronavirus complaints, employment complaints than any other industry at this time. And what are those, what are those complaints that we're seeing? Well, at first and foremost, there was the Families First Coronavirus Response Act that you all had to deal with. And we are now seeing long tail claims as a result of that. Did we give employees the right amount of time off? Did we terminate them when they wouldn't abide by mask mandates? Did you have employees that were asking for accommodations for disabilities in terms of, either being vaccinated or having to wear a mask? At the end of the day, the Families First FFCRA claims That started in March of 2020, and it required employers with fewer than 500 workers to provide employees with a certain amount of compensated time off. And we are seeing now the effects of decisions that boards made regarding how they were going to respond to that. We're also seeing retaliation claims bubbling up from, first responses from the coronavirus. For example, an employee of a hospital or an emergent care asserts that she was terminated for raising concerns about the lack of PPE, or says they were retaliated against for complaining that certain staff members weren't wearing masks correctly, or they were terminated for complaining about certain social events that an employer had that particular employee felt was not responsible in terms of responding to the coronavirus outbreak. There was a claim by a food manufacturer's nurse supervisor asserting that she was retaliated against for complaining about the employer's lack of preparedness for COVID-19 and raising safety concerns. That matter has settled out of court. But the amount of fees and expenses and time on this, small company, it was fewer than 100 employees, was quite devastating. And in fact, they, ended up, I'm not saying as a result of this lawsuit alone, but did end up, filing for bankruptcy protection. So, these are concerns, things that we need to look at. How are we responding? And how are we responding now in the world of required vaccinations? We've heard the news that there may be some legislation coming down that employers with over 100 employees can, the government may mandate vaccines. What are we going to do about that? We've seen a lot of employment claims in the area of failing to allow for leaves of absences for individuals who assert they have high risk conditions, autoimmune sensitivities, failure to implement proper screening. How are we doing on, I don't know about you, but there was a time where every day I'd come to work and I'd have to have my temperature taken, or I'd go into a courthouse, I'd have to have my temperature taken. That has clearly gone by the wayside. But there are lawsuits, again, arising from conditions back in, summer of 2020. But, the fear is as we lax and we all get used to being involved in, COVID-19 and it becomes a part of everyday life, are we still implementing proper screening? Are we still implementing social distancing? Are you still implementing protective measures? Because you as a board are required to continually, we're going to get into this in a second, but continually think about compliance, the safety of your employees, and the safety of your customers as well. There's also a rise in civil rights violation claims for requiring mask wearing, civil rights violation claims for requiring vaccinations. And I know as I say this, I hear it too. I hear it in every presentation I give, which is, so you're telling me I could get sued if I don't have them wear masks, and I could get sued if I do have them wear masks. And the answer is yes. I hate to say that. But to protect yourself as a board, and go back to Optima's last year, their bite-sized learning, we talked about protections for D's and O's from lawsuits. And one of those is the business judgment rule. And if you as a board can show that you thought about, considered, and made a logical implementation of a plan to protect your employees and your customers, you will be protected against any future claims. It's not to say they won't be made, but you'll have a defense. And so I know while it seems difficult to say, well, I don't know which way to go, should we require it, should we not? If your board notes, and I'm going to get to that in 1 second, but if your board notes talk about the fact that you as a board discussed with management the best and optimal way to protect your employees and your customers while still continuing your business, you're going to be protected under the business judgment rule. these are securities claims. You know, a lot of you don't deal with Securities Act violations, but I just want to say in the world of COVID, there are still breaches of fiduciary duty and negligence. And part of what you have to do as a board is not only implement things, protocols to protect your employees and customers, but you also need to be clear with your investors or, you know, banks. One of the things that you have a duty to do is a duty of candor as a director or officer. And what that means is you need to report properly, accurately, and specifically to your lenders, to your investors about what you're doing in terms of COVID-19 protocol. Directors and officers, and I just mentioned, you know, the Securities Act of 1983 and the anti-fraud provisions of the 1934 Securities Act 10b-5, because a lot of large publicly traded companies get in trouble with this, but there are state common law statutes in every state that you're operating in that also require you to have fair and accurate reporting with your investors, with your lenders. And that fair and accurate reporting, the courts are now saying, includes reporting accurately about how COVID has affected your business financially, what you're doing as a board to stop any, you know, financial implications from the COVID-19 pandemic, and what you're doing to protect your employees and customers. And so you have to have those meetings and discuss what protocols that you're putting in place. And then you have to be honest with your lenders and your investors and your shareholders to the extent you have them, or members if you're an LLC. Next, lack of corporate governance. There are always claims against directors and officers about lack of corporate governance. And we're going to have another bite-sized learning about Caremark issues. So if this is something that's of interest to you, tune into that one as well. But there will be, or can be, and have been lawsuits against boards related to the protocols the company had in place for handling. So we talked about employment claims related to the fact that, you know, maybe we retaliated against somebody because they complained, or an employment claim for constructive discharge. I couldn't work there anymore because they weren't putting into place the proper COVID protocols to protect me. So that's an employment claim. And now we're talking about a shareholder or member claim that you as a board failed to put the proper protocols in place and failed to implement them. And that is a derivative action that would be brought by the company against the directors and officers for failing to handle the pandemic and the potential claim, or the pandemic protocols, related to COVID-19. And so again, you need as a board to have those in place, and you need to make sure you're complying with not only the government regulations, but you have to comply with your own protocols. If you're putting them in place, you've got to comply. And the Caremark doctrine talks about, it's the seminal doctrine in Delaware, which requires directors to monitor the corporation's compliance with the law and to address any red flags it may have. And so gone are the days 20 years ago when I started representing boards and the board just sort of rubber stamped whatever the management was doing, right? You've got a smaller company, you've got a board of 6-7 people. You know, they may be paid, they may not be paid board members, and they're rubber stamping what's going on. The Caremark doctrine says that's not happening anymore. You as a board are charged with making sure that your management is implementing federal regulations, compliance, and its own internal protocols. And so that means you as a board have to be educated about what those protocols are, what the ever-changing landscape of COVID regulations are. And again, we're going to have another bite-sized learning on that issue in more detail. Another potential avenue for risk is safety. And we sort of covered this with respect to the employment claims, but these are claims that could arise from your customer base regarding safety, PPE failures, failure to enforce HR policies, privacy related issues. And that kind of gets me into cybersecurity. The work from home environment that we've all found ourselves in, and I know a lot of healthcare industries went to hybrid, telemedicine, remote workers. This has caused a significant shift in how companies are doing business. We have sent people home to their home office. I'm in mine today, to their home office, and boards were not ready for that. Most smaller boards were not ready for that. So the question becomes, do we have procedures in place for making sure that the work is done completely and accurately on time? Have you as a board made sure and had meetings with your IT people about whether or not the network security is where it should be? In the healthcare industry, we're dealing with personally identifying information. There's HIPAA issues, and there are a lot of landmines in the healthcare industry that might not exist if you're, manufacturing, mattress springs, right? So not only is it important to make sure that your hybrid employees that are working from home have what they need to work from home and that it's safe and secure, but you have an added layer in the healthcare industry when you deal with personally identifying information and potentially, HIPAA issues. And so what are you doing as a board to make sure that your network securities have been upgraded and are meeting the standard of care for the new work from home environment? So at the end of the day, what everybody wants to know is, how do we, what do we do to reduce our potential exposure for employment claims? Because I will tell you right now, of the D&O claims that we see, 80 to 85% of them are employment related against directors and officers. Wage claims, retaliation claims, discrimination claims, and in many states, the individual directors and officers who made the ultimate decision to either, terminate an employee or reduce salary or things like that can be exposed individually as well. Your D&O policy, which I hope you have one, would cover you and would certainly, take a lot of the stress out of that. But employment claims are on the rise generally. They're certainly, as I talked about at the beginning of this, on the rise as to the healthcare industry. And you need to make sure you have a policy in place to protect yourself, but that's not enough. You also have to take steps as a board to limit your liability. So know your obligations for federal and state law regarding employees' protected leave as it relates to COVID, as it relates to everything, but we're talking specifically about COVID. Know the rules and regulations. If you don't know them, make sure you have an HR person that's reporting to you as a board and is making sure that you have the information you need as a board to make decisions on behalf of the company. Make sure you revise your policies as necessary to incorporate these new regulations that are applying to COVID-19 exposures and sick leave. To the extent feasible, if you are offering telenetworking opportunities to your eligible employees, if you are putting them in a remote work environment or a work from home environment, make sure you have an HR policy about that, how it's going to work. Make sure you implement a system for recording employees' leaves and the reasons for supporting their leave of absence. I mean, as a defense attorney, there is nothing more frustrating than when a board says, well, we fired her because she was always tardy, always taking time off, and her performance was horrible. And I say, fine, send me her personnel records and let me take a look. And lo and behold, this woman, nobody ever documented her absences, and she's always gotten great reviews. I mean, there's, lawyers, we will do a great job for you, but we're not magicians. So, you need to make sure you're documenting what you need to document, or your HR department is, and that you are, as a board, overseeing them appropriately. The biggest concern for most employers are, what do I do about asking for proof of vaccination? Do I have to require vaccination in order? Can I fire them if they're refusing to get vaccinated? And I wish I had a very concrete answer for all of you, but unfortunately, that's still in a state of flux as of September 21st, 2021. But if it is something you're going to do, if you're going to require proof of vaccination to come into the office, make sure you consult with legal counsel in your state. Several jurisdictions have implemented laws banning employers from requiring vaccination passports. So if that's something you're going to do, I would suggest that you talk with legal counsel and make sure that you're making the right decision. And once that decision is made, that it is documented and fully explained to your employees. So, nothing wrong with encouraging vaccination. We certainly do that at my law firm of 1,000 lawyers. But if you're going to go as far as to require it, I would talk to some legal counsel in your geographic area. So in sum, this is my offices, but in sum, I want to encourage all of you to make discussions of COVID-19 something that occurs at your board meetings. I know everyone's sick of hearing about it. I know everyone's sick of dealing with it. But as a director and officer of a company, you have an absolute duty of loyalty to your company to make sure you're understanding the management HR policies on COVID, that you agree with them, that if called to testify someday, you could support them, and that you are overseeing your company's compliance with these new regulations. And the other thing I encourage most of my clients to do is not only make a COVID-19 discussion part of your regular board meeting, but also maybe make it a discussion to discuss new and emerging rules and regulations in your specific industry or geographic area to make sure that you are complying with your Caremark duties. So that's my bite-sized learning for today. This is my email address. If anybody ever wants to send me an email and has a question, I'm happy to have a discussion with you. So thank you, Millie.
Hey, thank you, Kim. And thanks to our listeners for taking time from your busy days. We hope you found this information valuable. If you've not done so already, we encourage you to view all 4 of our D&O recordings and share them with your board. And, we want these to be accessible to everybody who they apply to. So goodbye, everyone, and have a great day.